من الأفضل بس يضعه في ميوت حتى حين الحاجة لاستخدامه.
Inshallah, a number of the people on today's webinar were in Dubai for Dubai arbitration last week, which was a big success. And our congratulations to our hosts in Dubai for providing yet again an excellent platform for all of us to do what we do together. And of course, this was the first time for most of us in almost 2 years to actually be in the presence of other human beings who are not immediate family members. And so it was a very, very special time, I think, for many people, and it was a big success. So congratulations to Dubai Arbitration Week. And we look forward, inshallah, to being there next year once again. And SCCA closed the week with a very well-attended event, which included, among others, His Excellency Sheikh Suleiman, who I'll be introducing shortly, in attendance, and to great effect. And we're very proud of his performance and that of the whole team, and the Rais al-Tanfidi, Ustad Dr. Hamid Mira. I think Mr. Masad is going to give us the thumbs up that we are synced with YouTube any second, and we can begin in earnest.
Yes, Assalamu alaikum and good afternoon everyone. I will mention this message just only for the Arabic speakers. السلام عليكم. تتوفر ترجمة فورية للندوة، وبإمكان الحصول على الترجمة بالضغط على الأيقونة على اليمين بشكل الكرة الأرضية تحت مسمى Interpretation. تعطي خيارين، اللغة العربية والإنجليزية، وإمكانية التحويل ما بينهما حسب رغبتكم، وبالتوفيق. الآن أحيل الميكروفون لإدارة الحوار للندوة مع السيد جيمس ماكفيرسون. Mr. James, please, the mic is yours.
Thank you very much, Musad. That was Musad Al-Kharb, who is one of our directors of marketing and business development. So I'd like to welcome everyone to this, our second UNCITRAL SCCA webinar. And it gives me great pleasure, obviously, that we're going to be exploring a lot of different aspects of the Singapore Convention on mediation, and specifically the development and issues that have arisen over its first year. And to begin, I have the honor of welcoming leaders from our respective organizations, Dr. Hamid Mira, Chief Executive Officer of the Saudi Center for Commercial Arbitration, SCCA, and also, once again, our partner and co-host, Ms. Anna Joubin-Brett, Secretary of UNCITRAL. Dr. Hamid?
Ladies and gentlemen, Your Excellency, Ms. Anna Joubin-Brett, Your Excellency, Sheikh Suleiman Al-Ulayan, and ladies and gentlemen, distinguished guests, good morning, good afternoon, good evening, all around the world. First of all, it's great pleasure and honor for me personally and for SCCA, on behalf of SCCA, to conduct this very important webinar in partnership with UNCITRAL. First of all, please allow me to thank Ms. Anna Joubin personally, to thank her for her continuous support and help of SCCA and for the industry globally, and giving more importance for spreading the awareness related to ADR in the region. Also, I would like to thank her for giving us the opportunity to conduct the opening remark today in this webinar. At the same time, I would like to thank UNCITRAL institutionally for all ways of cooperation. One of that cooperation has been illustrated in 2 series of events. The first one related to CISG, and the other one is related to mediation and Singapore Convention in particular. Today is the second episode of our joint organized webinar related to Singapore Convention or to mediation in general. I don't want to take that much of your time. Just I would like to shed light about the effort has been conducted in terms of Saudi as a country and SCCA as an institution. First of all, Saudi is committed to support the mediation, conciliation globally and internationally and nationally. First of all, the country leadership will has been illustrated in different steps, starting to enable, foster, support ADR generally and mediation, conciliation in particular. to reach more access to justice, and that in the spirit of the Saudi Vision 2030, as part of attracting FDIs, facilitating businesses, enhancing the business's environment, attractiveness, and competitiveness. You can see some of the steps that I can give examples. Internationally, Saudi Arabia is the 4th country globally to ratify the Singapore Convention related to the enforcement of the settlement coming out of the mediation. Also, Saudi Arabia is one of the founding signatories. Another aspect is the legislative support to ADR generally and mediation conciliation in particular. For example, the new franchise law has been enacted just recently, has been mentioned in that law that the dispute coming out of these kind of contracts could be settled through mediation, conciliation, arbitration. In addition to the new commercial law and also the new judicial fees law, and I think His Excellency Judge Sulaiman will shed light about it in details. The third aspect related, or just to give an example about the Saudi support for mediation, conciliation, is the great judicial support. I think the cooperation with Minister of Justice has illustrated in different ways, and I will shed light about it just in a few seconds. And I think His Excellency Judge Sulaiman also will give a lot of details related to that in terms of the judicial support generally, and also some of cooperation areas with SCCA. Moving from a country to SCCA as an institution, I can just summarize that in 4 or 5 points. First of all, the technical infrastructure. Among very few ADR institutions in the whole MENA region, SCCA is providing sophisticated mediation services by issuing in early 2016 or 17 dedicated mediation rules within international best practices. In addition to that, SCCA has always encouraged the step clauses which enable parties to mediate first before they go to arbitration. Also, there is financial, you can say, privilege and just to help the parties to use mediation. And we witnessed in SCCA number of cases, the parties, they registered the case for arbitration, and after we offered them to use or to try mediation, they settled the dispute after one of these cases from the first session. Another aspect, we have also a dedicated roster for mediators from all around the world. They are well diverse in terms of gender, in terms of ages, in terms of nationalities, languages, specialties, etc. The other aspect that also I would like to just to shed light about is the specialized training capacity building in that regard. It's not a secret that mediation is, you can say, almost new in the region, generally speaking. Because of that, we tried since the establishment of the CCA to align with and to have a cooperation with different international organizations to conduct a very specialized program such as AAA, the American Arbitration Association, and their international arm, the International Center for Dispute Resolution, ICDR. We did that several times, and also we will do another very sophisticated program in December, and we will do that, and we will repeat that, inshallah. Next year, we are doing that in Arabic and English at the same time. Other aspect is the cooperation with Minister of Justice. Again, this is very important, and I can call it as the cornerstone. First of all, we signed with MOJ by a support from His Excellency, the Minister, Dr. Walid Al-Sam'ani, in 2019, and part of that, that cooperation agreement is to start a pilot project, related to mediation. In pilot 1, we started physically to refer cases from the commercial court in Riyadh to SCCA, and the settlement ratio was very great. During the pandemic, we started the pilot 2, which was virtually through Taradi platform, and I think His Excellency Sheikh Sulaiman will give more details about Taradi platform. So more than 108 plus cases referred to be registered before SCCA for mediation from the Ministry of Justice. One of the aspects, I think it's very important, and it's, I can say, it's the direct translation of the Singapore Convention locally, is the in cooperation and coordination with the Minister of Justice, and especially their arm, the Conciliation Center, that we could, during the pandemic, to start the initiative to convert the parties' settlement out of the mediation to be converted into enforcement title without going back to the courts, which is a great achievement. And we saw how much that aspect supported mediation and conciliation and make party more encouraged to use mediation and conciliation. I don't want to take that much of your time. I would like to thank all of you for attending this important webinars. I would like to thank all our esteemed speakers. And again, I would like to thank Her Excellency, Ms. Anna Joubert. Thank you very much.
Ms. Anna.
Thank you very much. I'm sending greetings from a very sunny day in Vienna. You can see that it's sunny because I'm fighting with the blinds here to get some shade and to not look like a zebra, but I'm very sorry I'm not able, but I'm not going to complain about the sun because we are starting to get into the winter season here, and so any moment, any ray of sun is very welcome. And it's with this sunny spirit that I'm joining you all for this webinar that is organized again jointly between UNCITRAL and SCCA. It's a great pleasure for us and a great honor to be co-organizing this this series of activities, and particularly the one today, because it's going to focus on one of our flagship instruments, namely the Singapore Convention. And as my good friend, Dr. Mehra, already mentioned, the Singapore Convention has been signed on and ratified by Saudi Arabia at the very outset of the opening for signature, and Saudi Arabia was among the first countries to ratify it. So this is a very strong signal that we are very pleased to acknowledge, but also very pleased to accompany through the events and activities that are organized to further strengthen the application and the interpretation and the good use of the Singapore Convention in the Kingdom of Saudi Arabia. Now, we heard with great pleasure all the achievements of the SCCA in the last couple of months. And I would be remiss if I did not mention as well the achievements of UNCITRAL, because we are working, of course, for all of you and for the greater good to develop a very comprehensive framework for mediation. So when the Singapore Convention was open for signature in 2019, and subsequently came into force in September 2020, we had to align and also develop additional texts and instruments to ensure that the framework for mediation would be complete, just as the framework for arbitration is complete, ranging from the New York Convention to the model law, to the arbitration rules, to the notes, and to various other texts that support parties in these disputes. Now, we have done exactly the same thing since the Commission session of this summer, and we have a framework now for mediation that is equally complete. Interestingly, unlike in the framework for arbitration, where it started with the convention and then trickled down into the various texts, here we have started from the bottom up, and we have concluded with the convention. So UNCITRAL had developed over the years rules on conciliation as well as a model law on conciliation. And what we had to do now was really to update all these instruments, existing instruments, to ensure that they are perfectly coherent with the Singapore Convention, and also to strengthen the framework with a few additional texts. And this is what we did. The Commission, at its 54th session, adopted 3 texts in the area of mediation. One is the guide to enactment of the model law on mediation. The other one is a text on the rules, the rules for mediation, which are now the UNCITRAL set of rules on mediation. And the third one is a series of notes and recommendations prepared by the Secretariat and endorsed by the Commission to help parties engage in a mediation, give them guidance, and give them indications about what they have to prepare for and be mindful of when engaging in a mediation process. So we have now a very complete framework for mediation. We have a convention, we have a model law, we have a guide to enactment for the model law, we have rules, we have notes. So the parties have everything they need to conduct an arbitration, a mediation, which will be fully supported by the UNCITRAL framework. And we're very proud of that, of course. And this joint event here with SCCA is for us a means of showcasing, of explaining what these instruments contain, and also of promoting the further use of the Singapore Convention and all the instruments that follow. So just to wrap up and wish you a very successful and very interesting and enriching webinar, I leave you in the best of hands. I leave you in the hands of my colleague, Corinne Montineri. Corinne has been watching over arbitration and mediation in UNCITRAL for many years. She has been the Secretary of Working Group 2, the working group that prepared and finalized the Singapore Convention. So there's nobody better suited to speak about the Singapore Convention and all the recent developments in UNCITRAL than Corinne. So it's with this in mind that I leave you in her good hands, and thank you once again for joining with UNCITRAL to deliver a webinar such as the one we are organizing jointly today. Thank you very much.
Thank you, Ms. Anna, and thank you, Dr. Hamid, for your respective insightful remarks and support for this series of webinars. I'm delighted to report to everyone that we have people literally from around the world: South America, Pakistan, Bangladesh, Nigeria, Botswana, Spain, all across the world, Chile. So we're in very good company globally. And thank you, Ms. Anna, for your remarks about the framework itself, because that is indeed quite an impressive undertaking and of exceptional quality. And Dr. Hamid for his remarks about the ongoing and impressive achievements in the Kingdom vis-a-vis mediation. So let's get right at it. As your moderator, I'm going to be monitoring your questions in the chat, as I already indicated from noting all the various locations we've got. What I'd like to do is ask you just to put your questions in there, and I will endeavor to curate those. And I'd like to introduce you to our 3 expert presenters. We have, of course, as Ms. Anna said, stepping in for Ms. Judith Nieper is Corinne Montineri, Secretary of UNCITRAL Working Group 3. And then also we are happy to have with us Christian Alberti, who is the Chief Registrar and General Counsel of the SCCA. And then, of course, rounding out the team, a longstanding partner and champion of ADR within the Saudi government, His Excellence Sheikh Suleiman Aloyan, who, by the way, is Deputy Minister, or Wakil Musad, at the Court Affairs and Supervisor of the Conciliation Center associated with the Ministry of Justice. So we have an A team with us today. And what I was hoping to do initially is kick things off with the convention itself. So I'd like to invite Ms. Corinne the chance to orient us vis-a-vis the convention. And I'd like to invite our Riyadh team to put up the presentation at this time.
Thank you very much, James, and it's a pleasure to be here with so many participants from all parts of the world. I would like also to say that I'm very pleased to be here with colleagues from the Center. And I would like to thank the Center for their contributions to the work of Working Group 2. The SCCA has been participating in the works of Working Group 2 for quite a number of years and has also communicated in a very nice manner with us. And we learned a lot about the certain contexts and how our texts are put in operation. And that has been very useful also for the works of UNCITRAL going forward. So there has been a very, very nice working relation, and very pleased to be here with you all today. So I will introduce the Singapore Convention quite briefly, and also the framework, but Anna already gave you some indications about the framework, so I won't spend too much time on that. We can move to the next slide, where you will see the logo on the next slide. You will see the logo of the Singapore Convention, which was developed by the government of Singapore. They used an orchid flower as a symbol for the convention, and during the signing ceremony, they also named a flower, an orchid flower, special species after the convention. So that was quite something quite nice.
If I might, Madam,
yes.
Can we make it full screen? Because I think it's a bit small at this point. If they can, yes. If Riyadh can make it full screen.
Full screen and maybe move to the next slide.
C'est ça, exactement.
The Singapore Convention has been prepared by UNCITRAL. It's a UN Commission on International Trade Law. It's one of the commission of the General Assembly of the United Nations. And the conventions, after its preparation by and adoption by UNCITRAL, was formally, of course, adopted by the United Nations General Assembly, which was acting as a diplomatic conference. And the convention was adopted by unanimity. Of course, there was no vote. So the government of Singapore hosted the signing ceremony, and we have a nice picture of this signing ceremony with, as Anna mentioned, so the government of the Kingdom of Saudi Arabia taking part to the signing ceremony, signing the convention, and being among the very first countries to become a party to this convention. So once again, here we will, I think, learn a lot also from the experience of the kingdom in the implementation of the convention. So now if we could move to the next slides. Can move to the next slide. Because I would like to maybe talk to you a little bit more about what is the purpose of this convention. Why did we develop a convention on mediation? This proposal, as many of you know, is what was brought to UNCITRAL by the government of the United States of America. And the initial purpose in the explanations was really to build trust in mediation by having a robust and harmonized enforcement mechanism. Thank you. We can move to the next slide already. We can go to the next one. Yes. So the purpose was really to have this trust built in mediation, and we had also representatives of businesses coming to explain to us that this is really something that is missing, a real way to enforce settlement agreements resulting from mediation. There was not, when this was brought to UNCITRAL, there was not necessarily a unanimous welcome of this proposal, and some delegations were wondering why we need something like that, because settlement agreements are agreements and can be enforced as contracts, and mediation is very flexible. But others were considering that a settlement agreement is the conclusion of a process to solve a dispute, so can be a quasi-judicial instrument putting an end to a dispute, and so deserving a special enforcement mechanism. And after a year of deliberation, then it was decided that, yes, indeed, it's important to embark in some work on the preparation of instruments on enforcement of settlement agreements. And we prepared 2 instruments in parallel. We prepared this convention, Singapore Convention, and we also prepared the model law, a new section on the existing model law, which was dealing with enforcement. So the benefit of having model legislative provisions on enforcement is first for those countries which need some implementing legislation. So they will have the benefit of using the model law, which addresses the procedural mediation and the enforcement, and also is accompanied by a guide on use and enactments, so which is quite helpful and which is a new addition. And it's also helpful for countries that are not necessarily yet ready to go for a convention on this, but wants or needs to go step by step to get prepared to go up to the preparation of the adoption of a convention. So the Singapore Convention establishes a harmonized legal framework for the enforcement of settlement agreements, and also it brings certainty and stability in the framework on mediation. And also importantly for the United Nations agenda, it contributes to Sustainable Development Goal, the goal 16. So I am not so sure where we are in terms of the presentations because I can only see part of it. But if we could move to Article 1 concerning the scope of application of this convention. It's a convention which applies to international settlement agreements resulting from mediation concluded in writing and to solve a commercial dispute. And each one of these terms is defined in the convention. Thank you, we can stay where we are here. So we are defining in this convention what international means, because the convention establishes a cross-border mechanism for enforcement of settlement agreements. Of course, everything which is reference to in writing or a signature is to be understood also with the electronic communication means in mind. So it's not a strict and limited conception of in writing. And importantly, the way mediation is defined, it is defined as a process where parties attempt to reach an amicable settlement agreement of their dispute with the assistance of a third person, meaning that if it is called conciliation, or if it is called mini-trial, or if it is called with different names in different jurisdictions, the convention would still cover that process. So as I do not want to use too much of the time, we need to hear from the next speakers on how the convention is indeed applied. I will move directly to Article 5, which refers, thank you, to the grounds for refusing to grant relief. And there are 3 categories of grounds. One category refers to the disputing parties, that they have no capacity. It's quite usual. The second type of grounds relates to the settlement agreement in itself, that it would be null, void, it wouldn't be a final agreement, or that it would not be in line with the with its content. It would be enforcing going through the enforcement procedure would be in contradiction with the term of the agreement. And that was put as a possibility for the disputing parties to opt out of the convention. So that's a mechanism to build in the convention the necessary flexibility for the disputing parties. And the third and last set of grounds related to the mediation procedure. And here it was highly debated during the deliberations whether we should touch on the mediation procedure, because we do not want to go with this convention into the domestic mediation rules. We want to leave that to countries. So we are touching only on some very limited aspects of the mediation procedure. Moving on now maybe to last point I would like to touch on the convention. It's a reservations. It's Article 8. States which sign or adopt this convention can take two types of reservations. First, they can exclude the settlement agreements entered into by the state or by an agency, governmental agency. So that can be excluded if they want. And a second possibility is a state can declare that it will apply the convention to the extent that the disputing parties agree to the application of the convention in their settlement agreement. And that's an opt-in. So it's kind of double opt-in. You need first the government, the state, to join the convention and to take that reservation. And if it does so, then some parties may decide that the convention will apply, otherwise it will not apply. So these things you find in the conventions were meant, and you can feel that, to reconcile the various views on how things should work. And you could see how debated it has been when you look at the convention, even if it is a short text with only very few provisions. I will end now very briefly with the mediation framework, which is, I guess, 3 or 4 slides later, and we are happy to share the slides with the participants later on, so they can go through all the details we've put in there. As Anna Joubem has mentioned, we have a full set of instruments to cover the mediation procedure. It starts with the parties. They can use mediation rules of UNCTRA that have been revised this year, and they can use also the notes on mediations, which are not limited to UNCTRA mediation rules. It's not notes on how to use the rules. It's not notes on how a mediation could unfold. What are the practices, not the best practices, but the various practices that you can find in different parts of the world. So you have the notes and the rules for the parties. For the mediation centers, they can use the UNCTRA mediation rules, and we are going to develop recommendations on how to use the mediation rules for arbitral institutions. Now, for governments, when they want to set up a framework, we've got the Modello, which was initially adopted in 2002 and has been revised in 2018 with the addition of the part on enforcement. So you have also that for the governments when they want to have a strong framework on mediation. And then for cross-border relations and enforcement of settlement agreements entered into by commercial parties in different parts of the world, or when the settlement agreement is related to as an element of externality, of internationality, then you have the conventions which allows for smooth enforcement of the settlement agreement. I will end there, and I really look forward to hear from the very topical presentation that we will hear now in a minute. Thank you so much for your attention. Thank you.
James, your microphone.
Shukran jazilan, Christian. Once again, thank you very much, Corinne. That was excellent. And I wanted to get straight into the next presentation, because we will be returning to Corinne and subsequently Sheikh Suleiman. Chris, obviously, the Singapore Convention has had considerable uptake and has been embraced widely around the world and continues to do so. In fact, it's been viewed as a complementary tool, as was outlined by Ms. Anna, to the New York Convention. But we've also heard some criticism, and it's always good to speak to these things, whether they have merit or not. I will leave that to your discernment as an audience, and Chris as an expert as well. So in terms of the criticism that has been leveled, challenging the need for such a comprehensive legal framework to enforce international settlement agreements, could you perhaps discuss for us some of these general concerns and address maybe a criticism or two, if you will?
Excellent. Thank you so much, James. And I'm delighted to be with you, Your Excellencies, ladies and gentlemen. Pleasure to discuss indeed some of the criticisms that we have heard about the Singapore Convention. I should perhaps say as a disclaimer outside before I even start, I'm a genuine fan of the Singapore Convention and mediation in general. So take whatever my personal take is with a grain of salt, but I think I'm right on the arguments. And what I would like to do today is to briefly look at two questions, essentially. The first one is whether there's a genuine need for the Singapore Convention. That's one of those critical points we have heard. And the second aspect is about whether it is even counterproductive. So I will take these in turn. So as for the first point, is it generally needed? Some argue that there is no evidence that there is an issue with voluntary compliance with international settlement agreements that would justify an enforcement regime like the Singapore Convention. But it would be short-sighted to say that because there's no empirical data or not enough, the breach of mediated settlement agreements is inexistent. For one, perhaps while it's rare, in Saudi Arabia, it is not an uncommon phenomenon forcing aggrieved parties to resort to court, which is no one wants. The next question then is whether compliance could, so the critics, not already be achieved by existing tools. So traditionally what we have heard, what I have seen are two items. The first is the use of escrow agreements to reduce, if not eliminate, the chance that one party will perform to its detriment without reciprocal performance by the other party. The second argument that we hear is that of arbitration clauses to include those as a fallback position in case of a breach. And we'll take this two in turn. As for escrow agreements, the problem with the use of escrow agreements is that it only works when dealing with rational parties. What if a party has no intention to relinquish control over the funds or the documents to an escrow agent? Also, hedging with escrow agreements comes at additional costs no one usually wants to incur after recovery has been declared. Once the settlement agreement is in dry towels, then no one wants to really talk about extra costs here. Finally, how do you resolve the possibility that the parties' respective jurisdictions may address escrows significantly different, perhaps even in favor of one party or the other? So, in essence, there are a lot of questions that need to be answered after both sides have already come to an agreement over the underlying issues. And while escrow agreements may very well avoid that one party to a settlement agreement will fully perform to its detriment, it cannot simply eliminate the issue of recalcitrant parties not performing at all. For this to happen, the affected party would again need court assistance. Now, to the second point, arbitration, does the existence of the New York Convention already alleviate the need for a comprehensive legal framework to enforce international settlement agreements? That's the question we hear a lot. I would agree that adding an arbitration clause may come to some degree to deter parties from walking away from the agreement, knowing that an arbitration may follow in short order, but arbitration is still an adversarial process that must take its course and is potentially followed by enforcement proceeding. In addition, parties must also be careful to not lock themselves out of the benefits of the Singapore Convention by agreeing to submit any breach to the arbitration rather than straight to enforcement under the Convention. Now, any strategic decision on this issue turns, of course, on the question as to whether the state where the assets are is a contracting state to the Singapore Convention or the New York Convention. The latter, of course, giving access to 168 countries where to enforce an award. So very powerful tool there as well. Now, to conclude on the second point and answer the first question of this entire presentation, the discussed tools do not reach the level of assistance the Singapore Convention can provide. In fact, the mere existence of the convention itself alone has psychological impact on the parties, knowing that walking away from the settlement agreement is no longer a simple breach of a contract. You can still have your escrow agreement, but why not go straight to enforcement without further court intervention on the facts and subject matter? Now, my second part of the presentation deals with more specific issues I have seen happening, and that is whether the convention is even counterproductive. So some have argued that the Singapore Convention could potentially harm the international enforcement of mediated agreements. Among the reasons I've come across, three stood out really out, and I want to explore those with you today. The first two have to do with Article 5.1e that Corinne showed to us already. Article 5.1e, just to remind ourselves, provides that the competent authority may refuse to grant relief if the party that opposes the enforcement proves, among other things, and here it comes, that there was a serious breach by the mediator of applicable standards, and that absent such breach, that party would have not entered into the settlement agreement. So there is an element of causation built into Article 5.1e, or what I will call now going forward, mediator defense breach, or mediator breach defense. Now to the first point, and that has to do with the argument that there's a lack of good faith reliance element in Article 5. So some critics argue that the mediator breach defense against enforcement somehow overlooks the importance of good faith reliance in instructing domestic courts. And as this becomes particularly evident when settlement agreements provide for what I would call a staged performance, where party A performs first and party B's performance follows. For example, if party A performs in good faith reliance, that there is no issue with the settlement agreement, and then party B successfully raises the mediator breach defense, then party A is, so at least the critics, left in an even worse position than it would have been had the tainted settlement agreement been enforced. So in the absence of any direction in Article 5, the question critics grapple with is whether the courts can factor in good faith reliance by the first performer when exercising their discretion to enforce or not. Now, if precluded from doing so, then again, so the critics, this would lead to an even greater injustice than would be the case in enforcing the tainted settlement agreement. Here's my take on that. While good faith reliance is known to in CTRI texts, such as the CSG, for example, the drafters decided to not make this prescribed element in Article 5.1e. But Article 5.1e does not rule out court discretion either, by using words such as may refuse, not must refuse. To what extent this may open the door for the courts to factor in good faith reliance can, of course, become a contentious point. But on a more pragmatic standpoint, I think it is fair to say that the outcome would be good faith reliance becomes a driving factor in the decision. Could this somehow sway a court to enforce the settlement agreement when there is otherwise a textbook mediator breach defense available to party B? The defense itself exists, and if proven by B, would likely lead to the court's refusal to enforce, irrespective of party A's good faith reliance. And quite frankly, any other outcome would taking the criticisms at face value, add another wrong to the equation, and as the old adage goes, two wrongs do not make it right. So that cannot be the answer. And it is not that party A is left without any rights. If the settlement agreement is found to be unenforceable, party A will likely ask the court to order party B to return its performance, as this could otherwise lead to unjust enrichment. If anything, party A's good faith reliance may still play a role in the court's decision on costs. So in conclusion, and while good faith reliance has its place, Article 5.1e is a well-balanced provision to disincentivize mediators and parties alike to depart from standards applicable to the process. There's also a much larger policy here at play, and that is simply one, do not enforce international settlement agreements that are based on a breach. Now, moving on to the second point, and that is a criticism with regard to the fora. Is it inconvenient or not? Article 5 imposes no limitations on where such a mediator breach defense can be raised. This has led to some criticism that I would describe as a perceived inconvenient forum shopping problem, if you will. As a practical matter, such a defense will likely be brought in a forum where our recalcitrant party B has its assets, as that is, of course, where the relief is sought pursuant to Article 4 of the Convention. Now, critics question whether the Singapore Convention was not modeled after the New York Convention on this point by providing any defense would have to be brought, and let us call it for now the place of mediation, kind of mimicking the legal seat we all know in the context of arbitration under the New York Convention. Instead, the home court of party B will likely be the court that decides the defenses raised, as that is likely where the assets are. Now, the argument here made is that our recalcitrant party B could make the enforcement as cumbersome as possible by potentially requiring the court to obtain evidence from a foreign mediator abroad, or to obtain evidence as to the foreign law or foreign practice to understand the applicable standard. There are, however, some flaws in this criticism. It is not that the place of the enforcement comes as a surprise to party A either. Usually parties know very well where the assets are when they enter into the settlement agreement. And Corinne is more expert than me on this point, but I would assume that if the forum appears so inconvenient to the parties, they may be able to delegate the power to determine any defenses to a forum perceived as adequate and convenient. Now, this goes back to the idea of selecting a place of mediation for any legal battles. The question, however, remains, can such power be delegated, and would the enforcing court regard any such decision as final and binding? Another consideration is that the place where the assets are is the place where any actions of enforcement take place. To now impose, so the critics, a process similar to the vacator process promulgated by Article 5.1e, this time of the New York Convention, may very well be equal, if not more inconvenient. This approach would assume that the mediator breach defense be decided by the competent court of the country in which or under the law of which that settlement agreement has been signed. This could potentially lead to have to register your court proceeding twice, one to win the defense and one to stop enforcement, and that cannot be the answer either. So in conclusion, I hear and understand the criticism, but all things considered, the approach taken under Article 4 to put the decision over any defense in the hands of the courts where the relief is sought and where any enforcement action must then take place anyway, may not be so inconvenient after all. And it is not that the courts of the signatory country to the convention are unable to somehow deal with a straightforward breach of standard analysis. To the extent parties disagree, any such decision or power to decision can be delegated to a forum that the parties agree to, so that liberty to do so. Now, on my final point, the last criticism that I have come across that has to do with Article 1.2b. Article 1.2b provides that the convention does not apply to settlement agreements relating to employment law, among other things. Now, some take issue with the broad language of this provision, as the words relating to employment law may open the door to unwanted challenges in court over settlement agreements between two companies where part of the settlement agreement addresses employment matters. For example, think of a settlement agreement dismantling a joint venture that will likely address how assets should be distributed. It may also then include a clause for party A covenants to not employ staff that worked on the joint venture project. Now, if then a dispute arises solely over the clause addressing the asset distribution, then this bears the question of how the court would react if party B now argues that the entire settlement agreement does not fall under the regime of the convention. Obviously, party B's argument here would be that the covenant language in the agreement relates to employment law. Now, one would of course assume that the competent court would find that this outcome was not the intention of the drafters of the convention, but it may still lead to unnecessary litigation over this point, at least in the early years until we have a clear answer in case law. In case of a successful motion now to refuse enforcement, it will also be interesting to see whether the other non-affected independent clauses of the arbitration agreement, of the settlement agreement, survive and can be enforced. But again, and coming back to the initial question, all these points raised can hardly be summarized as making the convention counterproductive. Now, in conclusion, other features such as escrow agreements complement but do not replace the convention's purpose. Arbitration is, after all, another adversarial process with its own challenges. Also, some of the raised criticism I've addressed today show that there's room for some legitimate questions, but none amount to the level of calling the Singapore Convention counterproductive. Quite the opposite, I would argue. The convention has given parties the ability to enforce settlement agreements across borders, something so far only consent awards were able to do to some extent. The convention also does away with one of the key concerns of mediation, that is that a settlement agreement is just another contract that can be breached. The convention puts a stop to that, and in doing so, promotes and further encourages the use of mediation globally. And with that, I'll give you back to James, and I'm ready for any questions. Thank you.
Thank you very much. In fact, what I'd like to do, I'm going to ask Chris, because I've noted 2 questions for him, and then I'll have a question for Corinna, and then on to Sheikh Suleiman, where we have got a series of very practical questions that those considering mediation in the kingdom should know about, and also some of the activities and achievements related to mediation more broadly in the kingdom. In the case of Chris, I was interested, you mentioned the possibility of partial enforcement, and I was curious to know if there's any case law related on this point.
As always, I started to look at the convention itself. I could not find anything on point. Unfortunately, there is also, to my knowledge, nothing that I at least could find in terms of case law. But if you peruse around scholarly writings, you find very often at least the proposition that it should not be impossible, the same way we operate with awards, to just enforce or set aside that portion that is affected by a challenge. So I would suppose that it is possible to enforce those portions of a settlement agreement to the extent it still stands on its own feet. Meaning, if you strike off one clause of the settlement agreement, does that impact the rest of it? It's in its entirety, or can the rest survive because that what has been stricken down is not so essential, so crucial for the settlement agreement as a whole? So I hope that the answer is that we can, but I'm also happy to hear from our colleagues and friends at Untitled.
Interesting that you mentioned this, because in the recent report that is going to be more widely disseminated, and in terms of dissemination, I've had several people ask about Corinna's slides and also the overall presentation remarks. So to answer that immediately, we will be able to share the slides, as Anna and Corinne mentioned, and also the entire presentation will be available to be downloaded on YouTube, and so shared with colleagues, clients, and others. And if there's ever anything at any point that you're interested in knowing about, certainly feel free to reach out to any and all of those on this webinar, and also any and all of those within our respective organizations, because the dissemination of information is key. In terms of the cases, one of the things that Chris and Dr. Hamid and the team uncovered in their researches with the findings and the court decisions in the kingdom, over 500 of them, in fact, is that the courts have successfully been able to enforce partial awards if need be. And so I think that I support what Chris said, that in all likelihood, inshallah, we would see something similar if and when applicable and necessary in the context of mediation. Second and last question for Chris before we have any others, and then I move on to our other two presenters. You mentioned two existing tools to improve, but not obviously guarantee compliance. Is there anything else that the parties can deploy in this area?
What I've seen, and I think is a useful tool that again does not replace the Singapore Convention, but is a complementary tool, is to think about if a settlement agreement needs further documentation to be consummated, consumed. Is there anything that is necessary to fill out, particularly when it comes to real estate property? So a good settlement agreement would probably also say something along the lines that any further documents that may be needed to be executed among the parties or by one party to again consume the settlement agreement should be done if reasonable, if appropriate, so at least that both parties know what's coming if something additional is in the pipeline.
In fact, thank you very much. I think I'll move straight on to Sheikh Suleiman and come back to Corinne. And he has some very specific technical and, as I said earlier, practical questions that we've come up with that he might be able to answer. The first for Sheikh Suleiman is very relevant to this. What judicial, procedural, and other reforms have been undertaken since the Saudis signed the Singapore Convention in mediation? And do you think that these measures, judicial, procedural, or other reforms, will increase the popularity and use of mediation in Saudi Arabia? And just to remind anyone who hasn't, because I know it was explained in Arabic earlier, to the left of the leave button on your screen, if you select English, you'll be able to hear the learned remarks of His Excellency Sheikh Suleiman. With that. Oh, yeah, I think you're on mute, Your Excellency, as I was earlier.
السلام عليكم ورحمة الله وبركاته. حياكم الله جميعا وحيا الله الحضور، وأشكرك أستاذ جيمس على يعني حسن التقديم. وأنا الحقيقة سعيد جدا بأني يعني تداخلت أو شاركت معكم خلال فترة وجيزة يعني لا تزيد عن أسبوع في منتديين أنا أشوفهم أو أعتبرهم من أكبر المنتديات وأهمها. أنا هنا لا أمثل نفسي، وإنما أمثل الجهة التي أنتمي إليها، وزارة العدل. وحضوري في منتدى المقام في دبي وأيضا في هذا المنتدى دليل على اهتمام وزارة العدل في المملكة العربية السعودية ببدائل تسوية النزاعات بشكل عام، سواء كانت الوساطة أو التحكيم. وأنا ذكرت في المنتدى الذي أقيم في دبي أنه الوساطة والتحكيم بينهما ترابط وبينهما يعني تشابك وتقاطع في كثير من النقاط، وإن كان لكل أمر من الأمرين خصوصية. حقيقة يعني أجدد الشكر لك أستاذ جيمس، وأيضا أنا سعيد بالتحدث بوجود قامات وأشخاص لهم قدرهم ولهم مكانتهم في جانب الوساطة والتحكيم، أو نقول في بدائل تسوية النزاعات بشكل عام، الأستاذة آنا الأمين العام للجنة الأمم المتحدة للقانون التجاري الدولي الاندسترال. بداية يعني الحديث عن الإصلاحات، أو دعني أدخل في جواب السؤال حتى يعني لا أخذ وقت طويل في الحديث. الحقيقة يعني ممكن أن أقول أنه المملكة العربية السعودية بدأت بالإصلاحات المتعلقة ببدائل تسوية النزاعات أو بالوساطة قبل اتفاقية سنغافورة، ويمكن أن تكون اتفاقية سنغافورة هي جزء من الاهتمام وجزء من الإصلاح الموجود لدينا فيما يتعلق بالوساطة. أول ما يعني كان أول تنظيم لدينا يتعلق بالوساطة هو تنظيم مركز المصالحة أو مركز الوساطة الصادر بقرار مجلس الوزراء في عام 1434. ثم بعد ذلك أتت يعني، وأنا سأتكلم في جواب السؤال على جزئيتين، سأتكلم في الإصلاحات التشريعية ثم سأتكلم بالإصلاحات الإجرائية أو العملية على أرض الواقع. بالنسبة للتشريعية كما ذكرت تنظيم مركز المصالحة، ثم تلا بعد ذلك قواعد العمل في مكاتب المصالحة وإجراءاتها الصادرة بقرار معالي وزير العدل في عام 1440. أخذكم قليلا قبل هذا التاريخ. عندنا صدر نظام التنفيذ، والذي نص في المادة 9 على اعتبار محاضر الصلح التي تصدرها الجهات المخولة بذلك أو تصادق عليها المحاكم سندات تنفيذية. أيضا وجدنا أنه في بعض الأنظمة التي صدرت لدينا في المملكة العربية السعودية حديثا إشارة إلى موضوع الوساطة، وهذا يدل يعني على خلاف ما كنا نعهده في السابق في الأنظمة السابقة. بشكل عام لا نجد لعبارة الوساطة، الصلح، المصالحة، التسوية أي إشارة في النظام، لكن في العصر في السنوات الأخيرة وجدنا أو بدأنا نجد في الأنظمة لابد إشارة في مادة أو مادتين أو أكثر حسب السياق أنه شيء يتعلق بالوساطة أو المصالحة. مثلا نظام الإفلاس، وهو نظام تجاري متعلق بالإفلاس، في عام 2018 نص على أنه يجوز لأمين الإفلاس إجراء الصلح، الوساطة والتوفيق بين المدين وغيره بما فيه مصلحة أغلب الدائنين. هنا إشارة تدل على اهتمام في هذا الموضوع. نظام الامتياز التجاري مثلا نص عزز بدائل تسوية المنازعات من خلال النص صراحة على أنه هذه مادة موجودة في النظام، يجوز الاتفاق على تسوية المنازعات التي تنشأ عن اتفاقية الامتياز أو تطبيق النظام بوسائل بديلة كالتحكيم والوساطة والتوفيق. وهنا يعني نجد إشارة إلى أنه إمكانية استخدام الوساطة. يعني جاءت بعد ذلك اتفاقية الأمم المتحدة بشأن اتفاقية تسوية النزاعات، التسوية الدولية المنبثقة من الوساطة، اختصار أو بما يسمى اتفاقية سنغافورة، والتي صادقت عليها المملكة، وهي تعتبر رابع دولة تصادق عليها، وبدأت حيز التنفيذ في شهر نوفمبر 2020. وهنا نجد أنه المملكة بعد هذه الاتفاقية تطورت أيضا بشكل أكبر، وإن كانت كما ذكرت في السابق أنه الإصلاحات والاهتمام بالوساطة بدأ قبل الاتفاقية، والاتفاقية جزء من هذه الوساطة. عندنا بعد كذا صدر نظام المحاكم التجارية، والذي يعني هو يعتبر من أقوى الأنظمة التي ذكرت الوساطة والمصالحة بشكل قوي، بل أنه رتبت ولأول مرة نجدها في الأنظمة السعودية. ما أدري صوتي ينقطع. وجدنا أنه نظام المحاكم التجارية نص على أنه إدخال أن بعض القضايا لابد أن يسبق النظر فيها إحالة إلى الوساطة والمصالحة. وهنا يعني أنا أعتبره هذا تطور كبير وشيء عظيم في تاريخ التشريع السعودي، أنه لما أن يكون شرط دخولك للمحكمة أن يسبق هذا، وخصوصا نتكلم عن قضايا تجارية، أن يكون هذا أن يسبق هذا وساطة. وهذا نظام المحاكم جاء بعد توقيع اتفاقية سنغافورة، ويعتبر تطوير إجرائي وتشريعي، عفوا تطوير التشريعي عالي الجودة وعالي الأهمية، وتسليط الضوء للمتقاضين إلى النظر إلى الوسائل البديلة لتسوية النزاعات ويعني الاهتمام بها. لما جاءت جائحة كورونا وأظلت بظلالها على العالم، وجدنا أنه أيضا المملكة وضعت الوساطة ذات أهمية، وجعلت جميع القضايا، وأنا أقول جميع وأعني بكلمة جميع، أن جميع القضايا لا تنظر لدى المحاكم. وأتكلم عن القضايا المتأثرة بالجائحة. أي قضية تجارية متأثرة بجائحة كورونا لابد أنها لا تنظر في المحاكم إلا حتى تمر عن طريق الوسطاء والمصلحين ليقوموا بمحاولة الإصلاح والتسوية. من الإجراءات التصحيحية والإجراءات التي تدل على اهتمام المملكة بالوساطة نظام التكاليف القضائية، والصادر في عام 2021 أو 2021. وهذا ربما يعني يثير سؤال أنه كيف هذا النظام سيعكس الاهتمام بالوساطة، أو كيف سيسلط الضوء على الوساطة. وتكون الإجابة أنه هذا النظام يعني يثير انتباه الناس للوساطة ولتسوية النزاعات باعتبارها يعني إما مجانية في بعض المراكز، أو حتى بمقابل، ولكنها بلا شك أقل من المقابل المادي الذي سيكون في المحاكمة. وأنا أعرف أنه كثير من الدول في العالم سبقتنا في مسألة التكاليف القضائية، وأنه التقاضي ليس بالمجاني، ولكن في ظل التطور الإصلاحات الموجودة في المملكة، الإصلاحات التشريعية والنظامية، جاء هذا النظام والذي بلا شك سيعكس تطور كبير في المصالحة والتحكيم وبدال تسوية النزاعات بشكل عام. أيضا لدينا يعني، وهذا أيضا يمكن أثرته وذكرته في منتدى دبي، أنه التشريعات المتخصصة، التشريعات القضائية المتخصصة، الأنظمة المتخصصة التي يعني تجعل للمحاكم طريقة وآلية ونظام للنظر الموضوعي للقضايا، هذه أعلن عنها سمو ولي عهد المملكة الأمير محمد بن سلمان. وهذه بلا شك أنها ستعكس أيضا اهتمام بوسائل تسوية النزاعات الأخرى. وإن كنا نتكلم هنا عن الوساطة، فهي ستدعم الوساطة من زاوية صرح فيها معالي وزير العدل السعودي الدكتور أو الشيخ الدكتور وليد بن محمد الصنعاني، حيث قال إن هذه التشريعات ستعزز من تنبؤ بالحكم القضائي. نحن الآن في السعودية ليس لدينا تشريعات، فالتنبؤ لدينا بالحكم القضائي يعتبر نوعا ما ضعيف، ومن الصعوبة بمكان على المحامي أو حتى على المتخاصم أنه يعرف ما الحكم الذي سيحكم له أو عليه في القضية. بينما هذه التشريعات ستزيد من التنبؤ، مما يجعل الطرفين أو دعني أقول الطرف المحكوم عليه أو الذي يظن أن يكون الحكم عليه يلجأ للوساطة بشكل سريع وشكل أقوى، تخفيفا من كونه أن يصدر عليه حكم قضائي. فلا بلا شك أنه لما يكون الأمر ينتهي بالوساطة أخف من أو أقل ضررا مما حينما يصدر حكم قضائي. هذا من الناحية التشريعية، وفي أمثلة كثيرة لكن أقتصر على أهمها. أما من الناحية الإجرائية، فالحقيقة وزارة العدل، ولعل أبرز ما يعكس هذا مشاركتي وأنا ممثل لوزارة العدل، وقد أتيت ب يعني إذن وموافقة ودعم من وزارة العدل للمشاركة في هذا الملتقى والملتقى السابق، وأيضا سأشارك أنا أو غيري ممثلا عن وزارة العدل في الملتقيات القادمة التي تتبناها مركز السعودي للتحكيم التجاري أو غيرها، دعما منا أو دعما من وزارة العدل لهذه الوسائل. فلأن وزارة العدل، وهذا الكلام صرح به معالي وزير العدل أكثر من مرة، تعتبر الوساطة القطاع الرابع في وزارة العدل. لدينا 3 قطاعات كنا في السابق هي التي نتعامل معها: قطاع القضاء وقطاع التنفيذ وقطاع التوثيق. الآن أضفنا قطاع رابع في السنوات الأخيرة وهو قطاع المصالحة، وهو لا يقل أهمية عن القطاعات ال3، وهو داعم لها ومقوي لها. وأحد أكبر المبادرات التي موجودة في وزارة العدل، وأنا أتكلم عن مبادرات وزارة العدل ضمن رؤية المملكة أو ضمن برنامج التحول الوطني في رؤية المملكة 2030 هو مبادرة تفعيل منظومة المصالحة. ولذلك يعني أنا أعكس بعض الأشياء التي تمت من خلال هذه المبادرة. تم إنشاء مركز متخصص للمصالحة، وهذا المركز يندرج تحته أكثر من 500 مصلح ومصلحة.
The Mutarjim seems to have, we lost him about 30 seconds ago. Okay, تفضل. Sorry. Please continue.
أعيد الكلام ولا سمعته؟
Yes, صح.
أعيد أو أستمر؟
It was perfect until 30 seconds and then we lost the link.
شيخ سليمان فقط آخر 30 ثانية فقط اللي كان فيها الإشكال. الصوت واضح.
طيب أنا أتكلم عن يعني تطوير يعني الناحية الإجرائية، ومن ناحية الإجراءات اللي تمت من خلال وزارة العدل، أن وزارة العدل تعتبر المصالحة القطاع الرابع مع التوثيق والقضاء والتنفيذ. وأكبر المبادرات لدينا من ضمن أكبرها مبادرة تفعيل منظومة المصالحة، وهذه المبادرة نتج عنها عدد من الأمور، مثلا إنشاء مركز المصالحة، وهذا المركز يندرج تحته أكثر من 500 مصلح ومصلحة، ولديه مكاتب صلح منتشرة على مستوى مدن ومحافظات المملكة. وأيضا يوجد لدينا في داخل المركز مكتب نموذجي لمداولة الصلح، يعني تم تصميمه وإعداده حسب أفضل الممارسات العالمية. عندنا من التطورات الكبرى الحقيقة التي أحدثت تطور نوعي فيما يتعلق بالمصالحة إنشاء منصة تراضي. هذه المنصة منصة إلكترونية يمكن نتكلم عنها فيما بعد، منصة متكاملة تدير عملية الصلح بشكل إلكتروني. أيضا عملنا على تأهيل المصلحين والمصلحات وتدريبهم بالتعاون مع مركز متخصص لدينا يقال له مركز اسمه مركز التدريب العدلي. وأيضا لدينا برامج أخرى خارج مركز التدريب العدلي نقيمها نحن في المركز بالتعاون مع استشاري يعني لإعداد هذه البرامج التدريبية، بالإضافة إلى برامج نشاركها مع المراكز المتخصصة مثل مركز التحكيم، مركز السعودي التحكيم التجاري، لديهم برنامج متميز الحقيقة شارك فيه عدد من المصلحين لدينا يتعلق بالتحكيم بالوساطة التجارية واستفاد منه المصلحين لدينا. أيضا كما نتعاون مع مراكز أخرى فنأخذ من كل تخصص الشيء اللي نجده متخصص فيه لندرب مصلحين ليكونوا مصلحين لدينا جاهزين على أهبة الاستعداد لأي قضية مهما كانت تفاصيلها وتعقيداتها. من الأشياء المهمة التي نعمل عليها حقيقة نشر ثقافة الصلح وتعزيز ثقة المجتمع فيها، ولدينا حقيقة برامج إعلامية بالتعاون مع استشاريين متخصصين في هذا المجال لنشيع ثقافة الوساطة والصلح بين الناس وترك اللجوء أو عدم يعني نجعل خيار اللجوء للمحكمة هو الخيار الأخير، وأن هناك خيارات أفضل كالوساطة والتحكيم. لدينا أيضا وهذه ممكن نتكلم عنها فيما بعد الشراكة مع جميع الجهات الحكومية. نحن الآن نعمل على الشراكة مع جميع الجهات الحكومية وغير الحكومية في القطاع العام والقطاع الخاص والقطاع الثالث التي تمارس عملية الوساطة، ومن خلال هذه الشراكة نستطيع يعني أن نضمن أننا نستطيع أن نقيم الوساطة بكافة تخصصاتها الهندسية، الطبية، التجارية، العمالية، جميع التخصصات بشكل كامل وجهات مختلفة على يعني أولى الجهات التي بدأنا بالشراكة معها، وإن شاء الله يعني على طور توقيع اتفاقية كبرى. احنا بدأنا يعني ببداية يعني تجريبية، وفي طور إن شاء الله اتفاقية كبرى معهم المركز السعودي التحكيم التجاري، ووجدنا الحقيقة التعاون الجيد معهم ممكن يأتي حديث عنها. وهذه طبعا المصلح المسجل منصوص على بالنسبة يعني هو نظاما منصوص عليه في قواعد العمل بمكاتب المصالحة. أخيرا أختم بأنه من الأمور التي عملت عليها وزارة العدل يعني إعطاء الوساطة القوة وعطائها يعني القابلية لدى الناس، دعمها في تنفيذ محاضر الصلح. وهذه يمكن إذا كنت فهمت من خلال الترجمة التي ذكرها الأستاذ كريس أنه جزء من الإشكالية التي يعني قد يعني تعززها الاتفاقية، الاعتراف ودعم وثائق ومحاضر الصلح. نحن في المملكة العربية السعودية ندعم هذه المحاضر والوثائق التي تصدر من المصلحين باعتبارها سندات تنفيذية، وباعتبارها تنفذ بشكل مباشر ويتم تنفيذها بشكل إلكتروني بداية من تقديم الطلب وحتى نهايته. ممكن استعرض معكم في وقت لاحق بعض الأرقام. شكرا.
That was very insightful, and also it really speaks to the depth, breadth, and commitment level of the ministry and yourself in particular and your colleagues, because this is vital. We always talk about an ADR ecosystem where you've got the legislative, the judicial, the users, and the practitioners. It's very important that it be as sophisticated and comprehensive as you've outlined. We've talked about this in other contexts, and invariably people ask the question about confidentiality and without prejudice offers, because in many countries around the world, if a party makes an offer in the context of the mediation and the other party does not accept that offer, they, in subsequent arbitration, litigation, and so on, it's confidential, and so you cannot make reference to it. Now, this sort of a situation obviously makes it easier for parties to rely on the confidentiality of the mediation process. In the Kingdom of Saudi Arabia, do you have a sense of where this question of confidentiality of the mediation, things exchanged in the mediation, offers made, maybe even the admission of guilt? Somebody may in a mediation admit that it was their driver who caused the accident, but they are only doing this to reach a settlement in the mediation. To what extent do you think, or is it clear yet, it may yet be to be determined in the courts in Saudi Arabia, is there a clarity about the confidentiality of the mediation process? Do you have any sense of that for our participants?
حقيقة أستاذ جيمس أشكرك على السؤال، وهذا سؤال مهم ويعكس يعني دعني أقول يعكس فهمك العميق لما يتعلق بالوساطة، وربما يعني فات علي أن أشير إلى هذا في حديثي عن الإصلاحات المتعلقة بالوساطة. من أهم يعني مركز المصالحة والوساطة لدينا تقوم على عدة مبادئ ومنصوص عليها بالنص في قواعد العمل في مكاتب المصالحة وإجراءاته. ومن ضمن المبادئ المنصوص عليها السرية، وأنه لا يحق للوسيط أن يبدي أو يفشي أي سر يمكن أن يتداول أثناء عملية المصالحة. ويعني لا أخفيك سرا أنه نمنع لدينا جميع الوسطاء من أن يبدوا أي شيء يتعلق مما تم خلال جلسة الوساطة والمصالحة. ولدينا نظاما يمنع أن يكون الوسيط شاهد في القضية التي كان وسيطا فيها إلا في حدود ضيقة. وهذا يعني أعتبره من النقاط المهمة والتي تجعل الوساطة لها ذات خصوصية تختلف عن الجانب أو الجلسات القضائية، لأنه كما لا يخفاك أنه داخل الجلسات القضائية ما يتم إفشاؤه فهو يعتبر حجة يدان فيها الشخص الذي يتكلم فيه، والإقرار الذي يكون داخل مجلس القضاء هذا إقرار يعتبر من الأدلة التي ممكن أن يستند لديها أحد الطرفين. لكن حينما نتكلم عن الوساطة فإن ما يتم فيها هو يستخدم فقط لذات الموضوع الوساطة. إن تم الصلح فتمام والأمور جيدة وجميلة، ما تم الصلح يغلق جميع ما قيل في الوساطة. شكرا.
Perfection, Your Excellency, because this indication that Saudi Arabia is in complete alignment with international best practice is very important for a lot of the people around the world on this webinar and watching it subsequently. Not to mention a lot of people who will hear about this, because it's very comforting and reassuring to have this convergence of practice in the kingdom, because it's going to help people have real confidence that when they come to the kingdom to do a mediation, that they will have this. Thank you. One other question for Ms. Corinne. I wanted to ask her, I'd like to ask you where UNCITRAL expects implementation issues, and perhaps in relation to the scope or Article 5 itself. We've talked about this before, but I think this is very important.
Yes, thank you. Thank you very much for this question. This is really key. Before answering, I would like just to come back to what we heard from His Excellency Suleiman Olayan on the importance of having a framework put in place nationally. I think that's really a very important message to be brought to other jurisdictions who want also to develop mediation and develop themselves as a mediation place, to have well-trained mediators, and also to raise the awareness of judges about the convention. Things that are put in place through the training at the SECA and other initiatives. I think they are very, very key to the success of having such a framework domestically. And I would like also to thank Christian for having summarized so well all the criticism about the convention. I think it's very important to go through them. They also very well reflect the various views that were exchanged during the convention, and they help to better understand how we put this convention together, also knowing the different viewpoints. On implementation specifically, we hope that with this framework, parties will spontaneously comply with their settlement agreements, that we will not have to use the convention so much. But what we are going to look at very precisely at UNCITRAL is how judges apply Article 1, the scope. And there was one aspect that was important in the negotiation, is to avoid gaps and overlaps between the Singapore Convention, the New York Convention, the Hague Convention on Judgments. So how will all this work together? That's something we are going to look at very closely, and how judges navigate their decisions around these three instruments. That's something very important. And we also will look very closely at Article 5 and how these various grounds, which sometimes are a little bit repetitive, and we mentioned that, we said they are repetitive, some of them can work together. You don't need to look at each one of them when you are a judge. We are going to look and monitor closely this aspect also in terms of implementation. Thank you.
Merci, Corinne. And one final question for His Excellency, Sheikh Suleiman. Another question that comes up frequently when we do webinars is how neutrals are treated in different jurisdictions. So for example, and this is a very practical question because it has arbitrators have run afoul of the courts in some jurisdictions in the GCC and other parts of the world as well. And this has a bit of a chilling effect, shall we say. In terms of mediators mediating in the kingdom, in Saudi Arabia, do you have a sense of whether this question that mediators are immune from prosecution for doing their professional services, not if they break the law, obviously, or if they do something, profoundly criminal, illegal, or otherwise, but in terms of simply fulfilling their duties, responsibilities, roles, and services as a mediator. So in most jurisdictions, not all, but many, and I would submit the more mediation-friendly jurisdictions, you are, as a mediator, you needn't fear that you will be prosecuted as a mediator. Do you feel that there is any clarity in the Kingdom of Saudi Arabia about this question of mediator immunity from prosecution? So this question is for Sheikh Suleiman.
لو سمحت لي أستاذ جيمس ممكن تعيد السؤال، ما اتضح لي بشكل دقيق.
What was the Oh, yes, absolutely. So a mediator in most jurisdictions, especially countries and jurisdictions where they are deemed ADR friendly or mediation friendly, they will have this understanding that mediators and arbitrators are immune from prosecution for fulfilling their duties, because in some countries, arbitrators have actually been convicted of different things, even in some parts of the Arab world and elsewhere, for doing their work as an arbitrator. Now, I want to distinguish between outright criminal behavior. Obviously, everyone is subject to accountability, prosecution, and sanctions if they commit a crime. But the question is, if you are simply being a mediator, doing your responsibilities as a mediator, your role and function, do you believe that mediators have this international standard of immunity from prosecution, meaning that they can do their work as a mediator and not feel that they would be held, in court for something that they did as a mediator?
If you allow me, James, الشيخ سليمان حقيقة بشكل مختصر يتعلق السؤال حول حصانة ليست الحصانة بمعنى الحصانة القضائية، وإنما هل الوسيط أداء لمهامه معرض للمساءلة القانونية طبعا بلا شك خلال حالات ارتكاب جرائم أو مخالفة.
واضح دكتور. طيب حقيقة يعني نقطة جميلة تفضل بها الدكتور، أنه واضح أنه السؤال ليس مقصود الحصانة القضائية، وإنما الحصانة أي عدم الإدانة أو عدم يعني تكليفهم بمسؤولية تجاه قيامهم بعملية الوساطة. نحن حقيقة يعني دعني أتكلم عن نوعين من الوسطاء. وسطاء رسميون يعملون لدى جهات رسمية، مثلا كالوسطاء الذين يعملون لدينا في مركز مصالحة. فأتوقع أو أظن من الطبيعي أن سؤالك ليس متوجها لهم، لأن هؤلاء موظف عام يمارس عمله بشكل طبيعي، فمن الطبيعي أن لا يكون إذا لم يخطئ أو يرتكب جناية أنه يحال أو يحاكم بسبب الوساطة. حقيقة حنا الوساطة والتحكيم لدينا ربما نستطيع أن نقسمهم إلى قسمين: وسطاء ومحكمون رسميون ونظاميون، ويعني ينتمون إلى جهة رسمية أو حكومية سواء كانت أو إلى مركز رسمي معترف به يعني داخل الدولة. هؤلاء يعني خارج السؤال ولا أظنهم محل الاستشكال أو الإشكال. يبدو لي أنه في الوسطاء والمحكمون الأحرار الذين يمارسون دورهم بدون يعني أن يكونوا تحت مظلة أو تحت يعني إدارة معينة سواء مركز حكومي أو أهلي، لكنه مصرح بشكل رسمي. النظام التحكيم مثلا نجد أتاح الموضوع للمحكمين أو المحكمون المحكم الحر بأن يمارس التحكيم بدون أي عقوبة وبدون أي مخالفة، ولا يعتبر ما دام لم يتجاوز النظام والقانون أنه مدان أو مرتكب جريمة ما. يقال مثل هذا الأمر بالوساطة، ولكن في حدود معينة. يعني بعض الأمور لدينا يعني دعني مثلا أتكلم عن الوساطة التجارية إذا كنا يعني داخل يعني هذا نطاق حديثنا مركز التحكيم، مركز سعود التحكيم التجاري. فهؤلاء لا يعاقبهم القانون، وبالعكس نحن الآن نعمل على مشروع إلى أن يكون هؤلاء الوسطاء مسجلون لدينا، يستطيعون أن تكون يعني ما ينتج عنهم سندات تنفيذية تنفذ لدى محاكم التنفيذ. نحن الآن نرحب بهم ونفتح ذراعنا لهم، ونسعى أن يكونوا وسطاء رسميين، عفوا ليسوا رسميين، ولكن ما ينتج عنهم من عمل يكون رسمي مثبت يمكن تنفيذه لدى محاكم التنفيذ. يبقى حدود ضيقة يعني نتوقف نحن ضدها في خصوصيات معينة، مثل الوساطة في قضايا الأحوال الشخصية لها خصوصية معينة، وربما نضع بعض الحدود التي لا تمكن أي أحد بأنه يخوض غمار هذه الوساطة وأن يكون يعني يمارسها. لكن أنا أتكلم بحدود ضيقة جدا. أما بشكل عام فالوساطة متاحة للجميع، ونحن نرحب بالوسطاء ونسعى إلى أن يكون لدينا كعدد السكان وسطاء كلهم يسعون في حل الإشكالات القضائية. شكرا.
Perfect. Thank you so much, Your Excellency. Well, this is the perfect place to conclude the webinar today. I wanted to thank.
If you allow me, James, just And also, I would like also to give this intervention in Arabic just after His Excellency Sheikh Sulaiman. Sheikh Sulaiman حقيقة أتوقع مداخلتكم في غاية الأهمية، حيث أنها حقيقة تمس قضية في غاية الأهمية فيما يتعلق وهو يعني قضية concern كما يقال، أو شيء له اهتمام في الصناعة العالمية. ويعني حقيقة كما فهمنا من فضيلتكم في مداخلتكم القيمة حول رؤية المملكة فيما يتعلق سواء بالمحكمين أو الوسطاء اللي هو سماهم جيمس، تسمى في الصناعة النيوترز، المحايدون عموما، أنهم يعني لا تلحقهم المسؤولية القانونية فيما إلا في الحالات التي يخالفوا فيها، يرتكبوا فيها جناية أو يخالفوا فيها القانون أو النظام، وهو حقيقة يأتي مع أفضل الممارسات. بس أحببت أني كذلك أني أعزز حقيقة أهمية الرسالة اللي ذكرتوها فضيلتكم في عكس حقيقة سياسة توجه المملكة فيما يتعلق بهذا السياق، مخالفة لبعض الدول القليلة اللي هي استثناء، التي أحيانا ترتب مسؤولية نظامية أو قانونية أو تلاحق المحكمين الوسطاء حتى في الحالات التي لا يتم مخالفة النظام والقانون. فأحببت فقط أن أؤكد هذه الرسالة، أنه كما يقال to highlight أنه this message، فقط نبرز هذه الرسالة بشكل مقتضب وواضح. يعني حقيقة أريد مرة أخرى أن أشيد بهذه الرسالة حقيقة من فضيلتكم، الله يعطيكم الصحة والعافية.
صحيح. وممكن دكتورة أعزز هذا بأنه قواعد العمل في مركز المصالحة وإجراءاته نصت على المصلح المسجل، وهذا المصلح المسجل هو ليس موظفا حكوميا ولا رسميا، وإنما يمارس الوساطة بشكل حر، ولكن نسجله لدينا ليس لنضع عليه كنترول أو شيء معين، لا، ولأن لكي يكون ما ينتج عنه سند تنفيذي ينفذ في محاكم التنفيذ. وهذا أظن تجاوز الدعم إلى أنه عدم المعاقبة أو المجازات إلى دعمه كمصلح ودعم العمل الذي يقوم فيه.
يعطيكم العافية. Thank you, James.
Thank you very much, Sheikh Sulaiman, Dr. Mira. I wanted to thank everyone who participated from around the world. We literally have people who've logged in from the center in Tunis, from the center in Morocco, and so on. Literally around the world, we've got people with us today. And all of you for championing ADR generally around the world, we salute you. And our sincere thanks to our 5 speakers today, our host, Dr. Hamid Miraz, CEO, SCCA, and of course, our partner and co-host, Ms. Anna Jouvet-Bret, the Secretary of UNCITRAL, and also our 3 presenters. In this case, Ms. Corinne Montineri, Secretary of UNCITRAL Working Group 3, Christian Alberti, Chief of ADR and General Counsel, and of course, His Excellency Sheikh Sulaiman Al-Olayan, Deputy Minister with the Court Affairs and Supervisor of the Conciliation Center. This has been a wonderful day, and thank you all very much for your participation. And we look forward to seeing you at our next iteration of the webinar, which should be in the coming months. أستاذ.
تسمح لي أستاذ جيمس؟ يعني أنا ممكن ظننت أنه سيتاح المجال لي لأتحدث. أنا أعتذر أنه يعني أكون الخاتمة عندي أو أني أستأثر بالحديث، ولكني أجد أنه من الواجب علي أن أتحدث عن بعض الأرقام التي انعكست بعد اتفاقية سنغافورة، وأنه يعني أنا أدعو من هذا المنبر أنه الوساطة والمصالحة لدينا تحقق إنجازات كبيرة جدا، وهي بيئة جدا داعمة، وندعو الجميع في أنحاء العالم إلى أن يستفيدوا من الوساطة إن كانوا لا قدر الله خصوما، أو حتى إن كانوا وسطاء، يعني النظام لدينا لا يمنع أن يكون الوسيط حتى أجنبيا. لدينا منصة عملنا عليها، منصة إلكترونية، هي تعتبر المنصة الرسمية لاستقبال طلبات الوساطة حتى بدون أن تكون هناك دعوة في المحكمة، ممكن أن يدخل لها المستفيد مباشرة لطلب الوساطة. وهذا أظن منصوص عليه حتى في اتفاقية سنغافورة، أنه إتاحة المجال لتقديم الطلب مباشرة دون أن يكون هناك قضية منظورة لدى المحكمة. لدينا من خلال هذه المنصة خلال فترة 2 أو تزيد 900,000 مستفيد دخلوا من خلال هذه المنصة. لدينا 450,000 طلب أجري من خلال هذه المنصة. لدينا 512 مصلح ومصلحة، رجل وامرأة، كلاهما يمارسون عملية المصالحة بشكل جميل وجيد وناجح ولله الحمد. عقدت 275,000 جلسة لدينا. وهذا النقطة الأخيرة أختم بها، وهي مؤشر يعتبر ولله الحمد عالي جدا، فوق 82,000 وثيقة صلح تم اعتمادها وتم تنفيذها. شاكر لكم وشاكر للمركز السعودي للتحكيم التجاري، شاكر للزملاء والحاضرون جميعا، ومتشرف بتواجدي معكم، وأسف وأعتذر أنه أنا استأثرت بالحديث أو تكلمت بشكل طويل، لكن هي رسالة لابد أن أوجهها للجميع، وأقول مرحبا بكم لدينا في السعودية، مجال رحب وبيئة مناسبة جدا لبدائل تسوية النزاعات، التحكيم والوساطة.
Exactly. Well said, Your Excellency. And when you spoke last week in Dubai with Dr. Hamid and our team and the other excellencies, I think you saw the reaction of the international community that were assembled there. They were very positive. They were very pleased. And in fact, they themselves, especially the 6 practitioners we had in the last session, they spoke directly to their own experience in the kingdom. And these are all international lawyers, largely from Australia, UK, and elsewhere. And they themselves, at their own experience of arbitrating and mediating in Saudi Arabia, they were very, very positive. In fact, the phrase Saudi Arabia is as good as any other jurisdiction in the world, which one likes to hear these things, especially about one's own jurisdiction. So it was very positive. So thank you for mentioning those. I think it was important to highlight those at this time and with this audience. So shukran jazeelan, Ustad. So thank you all very much. And we look forward to seeing you soon, inshallah. Well done, everyone. Thank you so much. Ma salama.